Dear friends and dear colleagues, it is my extremely great pleasure to welcome you to the 2023 Gaillard Lecture. I do so on my own behalf and on behalf of my partners and colleagues, a number of whom are present today from both our Paris and London offices. These are Mohamed Shelbaya, Benjamin Sino, Coralie Darrigade, Jimena Herrera Bernal, Thomas Parigot, James Herbert, Anders Junker Nielsen, Ashish Mitter, and Nicolas Pralika. All in the front row, and they will come and say hello during the cocktail later today. As you may have noticed or will have read, consistent with late Professor Gaillard's transnational view of international arbitration, we decided that the Gaillard Lecture should be itinerant and travel the world, just as arbitrators and counsel routinely do. Lord Hoffman very kindly inaugurated the tradition last year in Paris, and we now have the immense pleasure and honor of benefiting from Lord Neuberger's wisdom here in London for the 2023 edition. For the 2024 edition, we will travel to Singapore and onwards to other horizons the following years. When we asked Lord Neuberger to deliver this year's lecture, he accepted right away, notwithstanding what I assume to be a challenging schedule. We were very touched, not least because his encounter with Emmanuel was limited to one case, just before COVID, in which Emmanuel appeared as lead counsel before Lord Neuberger, who was chairing the arbitral tribunal. It is an understatement to say that Emmanuel genuinely admired Lord Neuberger's mastery of both the arbitral procedure and the complex financial topics that were being debated and argued before him. More than once, he told me how lucky the international arbitration community was to have found such a high-caliber arbitrator. It was only natural then, given Emmanuel's true admiration for him, to ask Lord Neuberger to deliver the Gaillard Lecture this year. Lord Neuberger, of course, needs no introduction, but please allow me to say just a few words. He was born in the United Kingdom in 1948. He graduated with a degree in natural science from Oxford and worked at a merchant bank until he entered Lincoln's Inn and was called to the English bar in 1974. He was appointed Queen's Counsel in 1987 and became a bencher of Lincoln's Inn in 1993. From 1996 to 2004, he served as a judge of the Chancery Division of the High Court. He was appointed the Lord Justice of Appeal in 2004 and Lord of Appeal in Ordinary in 2007. He became Master of the Rolls in 2009, and in 2012, he was appointed President of the Supreme Court of the United Kingdom. He retired from that post in September 2017. In 2018, he became a judge of the Singapore International Commercial Court. He was elected an honorary fellow of the Royal Society in 2017 and is an honorary member of the Royal Institution of Chartered Surveyors. He was appointed Chancellor of the University of Law in 2018. He has received honorary doctorates from UCL, Queen Mary London, York, Exeter, and Oxford. He was awarded the Gold Bohemia Star in 2018. With this, I will now leave the floor to Lord Neuberger, who will discuss reasonableness and good faith in international arbitration law, following the lecture, which will take about 45 minutes. You are all invited to drinks and cocktail dinner in the cloisters in the courtyard. Lord Neuberger, thank you so much for being with us. Please.
Thank you very much. It's an honor to have been asked to give this lecture. Emmanuel Gaillard was an outstanding figure in the arbitration world. In the first rank as a writer of stimulating articles, as an inspiring teacher in Sciences Po, Harvard, and Yale, as a legal business developer, as a superlative advocate, as a very effective cross-examiner, and as an outstanding, many would say the outstanding, arbitrator of his time. He was accurately described as not just a brilliant advocate, arbitrator, and academic, but a passionate manager, mentor, and entrepreneur, fully engaged with all aspects of legal practice, as well as the theory behind it, and playing a transformative role in young practitioners' careers. He was a major player on the international stage, but as was also said of him, his quintessentially French style, as well as his frequent references to French culture, contributed to his role as a national poster boy. As Yaz has said, I had the pleasure of seeing Emmanuel Gaillard in action as an advocate in 2018. We were in Hong Kong. He made a brilliant job of a very difficult case. His combination of Gallic charm, intellectual rigor, command of language, and turn of phrase was almost mesmeric in its effect. As a presiding arbitrator listening to an advocate, one does not expect to feel like a fly trapped in a spider's web, but that's how I felt. In an interview with Neil Kaplan, Gaillard observed that he was in some respects more of a common lawyer than a civil lawyer. Although his specific reasons, his love of cross-examining witnesses, and his belief that costs should follow the event were not in point for present purposes, his observation is very much in point in the light of the topic of my lecture this evening, reasonable and good faith in international arbitration law. In the field of commercial law, English lawyers, indeed common lawyers generally, are very keen on invoking reasonableness, and that even more siren concept, common sense, whereas traditionally we've recoiled from invoking good faith, in contrast to the highly significant part it plays so far as civil law is concerned. Casting one's eyes more widely, there is undoubtedly a difference of approach between the common law, with its judge-made law built up on a case-by-case basis over the centuries, and civil law, where the law is laid down in detailed codes, which then have to be applied by the judges. The great essayist, lawyer, and scientist Francis Bacon wrote in 1620, "Those who have handled sciences have been either men of experiment or men of dogmas. The men of experiment are like the ant. They only collect and use. The reasoners resemble spiders who make cobwebs out of their own substance." It's something of a caricature, but I suggest that common lawyers are the experimenting ants who collect and use, developing the law on a case-by-case basis, preferring empirical, concrete solutions, whereas civil lawyers are the reasoning spiders who make cobwebs out of their own substance in the form of codes, proceeding deductively from broad principles. Another way of describing this distinction is that civil law systems are top-down, whereas the common law works on a bottom-up basis. The civil law has broad principles such as good faith, imposed as overarching philosophical rules, which the courts then have to apply. The principles are inevitably general and broad brush because they have to be applied in literally millions of different circumstances. The common law develops principles by reference to the facts of individual cases, and any principle derived from a case therefore tends to be relatively specific and limited. Hence, what common lawyers call estoppel is just one facet of the multifaceted principle of good faith in civil law, whereas as the common law has developed the law, there are more than 5 types of estoppel. This indeed reflects the constitutional differences between the United Kingdom and its European neighbours, and almost virtually every other democratic country in the world. Almost all democratic countries have an overriding constitution, by which I mean a single document which sets out, sometimes in detail, sometimes not, the fundamental government rules which are entrenched, in the sense that they cannot be easily changed, and which are overriding in the sense that they bind not only the judiciary and the executive, but also, at least to some extent, the legislature. By contrast, the UK system has developed on a piecemeal basis, with principles and practices being introduced, modified, and ditched as and when political, social, or economic pressures require, and with Parliament able freely to override or ignore them. A sort of make-it-up-as-you-go-along constitution. So in a country with such informal constitutional arrangements, it should come as no surprise if our law relating to the very important subject of contracts is nowhere codified, but instead is based on centuries of judge-made law. There have, of course, been occasional parliamentary interventions on what appear to be a characteristically haphazard basis on random topics, such as frustration, misrepresentation, and land contract formalities, and more recently, to a significant extent, arising from EU directives, protection for consumers and the like. When it comes to the basic attitude of common law judges to contract law, it's been consistent since the days of Lord Mansfield, possibly the greatest English Chief Justice, although ironically a Scotsman and allegedly a Jacobite, in the second half of the 18th century. And since then, English judges have prided themselves on a pragmatic and commercial approach to contract law. In one case, Lord Mansfield famously observed that the daily negotiations and property of merchants ought not to depend upon subtleties and niceties, but on rules easily learnt and easily retained, because they are the dictates of common sense drawn from the truth of the case. More recently, the approach of English judges was well expressed by the late Lord Gough in the following terms: "Our only desire is to give sensible commercial effect to the transaction. We are there to help businessmen, not to hinder them. We are there to give effect to their transaction, not to frustrate them. We are there to oil the wheels of commerce, not to put a spanner in the works or even grit in the oil." Two relevant and important points about the English approach can be confidently identified. First, to express it in modern language, the English law pays great respect to party autonomy. Judges are reluctant to interfere with or to gloss what the parties have written. Secondly, English law recognizes the importance of certainty to people in commerce, and therefore that the law has to be as clear and predictable as possible. Consequently, the common law is relatively reluctant to impose any moral standards on the parties, other than expecting them to behave honestly, not to tell lies. Thus, as has recently been emphasized by the UK's top court, the courts will give great weight to the words the parties have used when deciding what a contract means. A term will only be implied into a contract if the contract is unworkable or incoherent without the term, and the law does not recognize any sort of freestanding duty to negotiate in good faith. More specifically, as I've mentioned, the courts of England have rejected the notion that the general principle of good faith has a part to play in the context of the law of contract, unless, of course, the parties have agreed in their contract that they would act in good faith, in which case, of course, consistent with its general approach to commercial contracts, the common law would recognize that that is what the parties had agreed and would give effect to it. So when interpreting a contract, a common law court is simply concerned to identify the intention of the parties by reference to what a reasonable person, having all the background knowledge which would have been available to the parties, would have understood them to be using the language in the contract to mean. This is, of course, in some contrast to the civil law approach, where most contractual codes expressly incorporate a requirement of good faith into the law. It's not that much of an exaggeration to say that English contract law allows parties a blank canvas on which to carry on their negotiations and to make pretty well whatever agreement they wish, and thus accords the parties great flexibility. By contrast, civil law systems impose an overriding, non-derogable duty of good faith on those in a contractual relationship, or even on those contemplating such relationship. Article 1102 of the French Civil Code, while stating that parties are free to contract as they wish, also asserts that they may not derogate from public policy, ordre public, and the code then goes on to state that contracts must be negotiated, executed, and performed in good faith. To similar effect, the German Civil Code requires contracting parties to perform their obligations in good faith and in accordance with general custom and practice. The Spanish Civil Code has relevant provisions in that it stipulates that rights must be exercised in accordance with the requirements of good faith and negates abuse of rights or antisocial exercise of rights. Accordingly, when compared with the common law approach to commercial contracts, civil law is more concerned with the behavior of the parties in negotiations and in performance, and courts can sometimes invoke it to override or limit the effect of expressed terms. Consequently, the importance of party autonomy and predictability is reduced, and the outcome of a number of civil law cases, which in common law courts would be resolved by reference to what the parties had agreed, would turn on the view of the court as to whether a party had acted in accordance with what the law on good faith requires. Consistent with this approach, it seems to me that when working out what a contract means, a common law court's approach can in practice be said to involve asking what reasonable people in the position of the parties would have meant, whereas a civil law court ultimately asks itself what the two contracting parties subjectively intended based on their volonté psychologique reflected in the UNIDROIT principles of international commercial contracts. More generally, in the civil law system, leading academics have said that in the field of contract law, there's an omnipresent obligation of good faith, and that good faith is the primary means through which the moral rule was made to infiltrate the positive law. And while acknowledging its subjectivity, another leading academic has described the role of good faith when it comes to the judicial determination of contractual issues as irremplaçable, as it enables judges to penalize those who game their contractual arrangements to obtain an unjustified profits. Thus, at least in some jurisdictions with civil law, pulling out of negotiations without what the court regards as a good reason, not disclosing relevant information to the other party without being misleading or in breach of an express term, not assisting the other party to perform the contract, exercise a termination right in accordance with the contractual provisions, insisting on performance of the contract when circumstances have changed, could all represent breaches of good faith in many civil law systems, when in common law they would not normally be regarded as providing any cause of action or giving rise to a defence. Indeed, the French Civil Code entitles a party for whom unforeseeable circumstances renders the contract performance excessively onerous the right to seek renegotiated terms, and if renegotiation fails, either party may ask the court to revise or terminate the contract. In a recent in-depth paper, the UK Financial Markets Law Committee, when discussing the civil law concept of good faith, observed that the duty of good faith eludes definition. Its elusiveness is part of the key to its evolution. In case that appears to be a biased assessment by a group of disapproving common lawyers, I should add that closer to home, immediately after referring to the acceptance of the principle of good faith in international arbitration, the very experienced Spanish international commercial arbitrator Bernardo Cremades has written that, nevertheless, it is not clear what the concept of good faith actually means. And he cites the late Professor Luis Diaz-Paxo's description of good faith as one of the most difficult concepts to grasp within civil law, which has given rise to the longest and most passionate controversy. The Dutch Professor Hesselink has described good faith as a norm, the content of which cannot be established in an abstract way, but which depends on the circumstances of the case in which it must be applied. And Professor Terret of France has said, it will be up to the judges to rule on a case-by-case basis, taking into account the nature of the contractual relationship and the attitude adopted by each of the contracting parties. I must admit that this description brings to mind the remarks of my former colleague, Lord Sumption, in his retirement speech from the Supreme Court, when he listed the various judicial expressions which he said really meant we can do what we like. A kinder way of putting the point may be that, in reality, good faith may have many meanings, depending on the contractual setting, the act to be performed or not performed. A view of the present Chief Justice of Australia, Susan Kiefel. To import good faith into English law contracts in cases where parties have not agreed that their relationship would be governed by good faith would seem to traditional common lawyers to breach a number of important rules and practices of English contract law. First and foremost, it would be inconsistent with the two basic rules I've already mentioned, namely respect for party autonomy and the quest for certainty. The court would be imposing its own assessment of morality on the parties, which would eat away at their freedom and also leave them unsure as to what the effect would be. Further, to impose a duty of good faith on contracting parties would involve implying a term into their contract, and to do this in almost all cases where it could be said to be contrary to principle. As I briefly mentioned, a term can only be implied into a contract under common law if the contract would be unworkable or incoherent without the term. The traditional common law view was emphasized recently by the Court of Appeal in the MSC Mediterranean case, where it was said that there was a real danger that if a general principle of good faith was established, it would be invoked as often to undermine as to support the terms which the parties have reached in their agreement, a characteristically common law view. The stark difference in approach between civil and common law is well illustrated by the attitude to pre-contract negotiations. The traditional common law attitude is to be found in the robust observation of Lord Ackner in the 1996 case of Walford and Miles. The concept of a duty to carry on negotiations in good faith is inherently repugnant to the adversarial position of the parties when involved in negotiations. Each party is entitled to pursue his or her own interests, so long as he avoids making misrepresentations. To advance that interest, he must be entitled, if he thinks it appropriate, to threaten to withdraw from the negotiations or to withdraw in fact, in the hope that the opposite party may seek to reopen the negotiations by offering improved terms. By contrast, as I've mentioned, at least some civil law systems recognize that there is a legal duty on parties to negotiate in good faith, so that each must deal with the other in a spirit of cooperation and good faith and goodwill. Article 1112 of the French Code Civil provides in terms that negotiations must mandatorily satisfy the requirements of good faith, so that if a party breaks off negotiations without legitimate reasons, that party can be liable for breach of good faith. Indeed, Article 1112 interestingly contrasts with the English common law approach. A party who knows information which is of decisive importance for the consent of the other must inform him of it where the latter legitimately does not know the information. English law would merely say you can't tell a lie about it, but you can take advantage of your opponent's ignorance. The contrast of approach between the civil and common law is also well illustrated, albeit in less bleak and more informative terms, in the English Court of Appeal Interphoto case. In that case, the plaintiff's standard terms for hiring out certain products were contained in a delivery note, and they included a provision which meant that the defendant would have to pay a very substantial excess sum if the products were returned late, and owing to the defendant's oversight, they were returned late. Lord Justice Bingham, a great English judge, said, "In most legal systems outside the common law world, the law of obligations recognizes and enforces an overriding principle that in making and carrying out contracts, parties should act in good faith. This does not mean that they should not deceive each other simply, a principle which any legal system would recognize. It is in essence a principle of fair and open dealing. In such a forum, it might, I think, be held on the facts of this case that the plaintiffs were under a duty in all fairness to draw the defendant's attention specifically to the high price payable if the products were not returned in time. English law has characteristically committed itself to no such overriding principle." However, as he went on to explain, while the common law has generally rejected the notion of good faith applied to contractual relationships, it has developed, as I mentioned, specific doctrines or rules which taken together can fairly be said to go a significant way to filling the hole which a civil lawyer may feel exists in a legal system which does not imply a duty of good faith into contract law. The point was made by Lord Justice Bingham when he said, English law has developed piecemeal solutions in response to demonstrated problems of unfairness. Many examples could be given. Thus, equity has intervened to strike down unconscionable bargains. That very point was demonstrated by the outcome of the Interphoto case, where the Court of Appeal held that the defendant could escape liability for the increased sum by relying on a judge-made rule that, where a condition is particularly onerous or unusual, the party seeking to enforce it must show that that condition was fairly brought to the notice of the other party. A good example of the common law having and developing a specific rule through the courts, which would be a small part of the overall good faith rule which the civil law has developed. A significant example of a common law rule which might at first sight appear to go a significant way to reflecting the principle of good faith can be traced back 150 years, when in a case called Mackay and Dick, the House of Lords laid down the proposition that it is a general rule applicable to every contract that each party agrees by implication to do all such things as are necessary on his part to enable the other party to have the benefit of the contract. But it's clear from subsequent cases that this duty is a much more limited duty than a civil lawyer might expect. Thus, in a recent case, Mr. Justice Cook said, the law can only enforce a duty of cooperation to the extent that it is necessary to make the contract workable. The court cannot, by implication of such a duty, exact a higher degree of cooperation than that which could be defined by reference to the necessities of the contract. The duty of cooperation or prevention or inhibition of performance is required to be determined not by what might appear to be reasonable, but by the obligations imposed upon each party by the agreement itself. A good example how the common law courts don't just invoke reasonableness when the civil law courts invoke good faith. Reasonableness is a vital feature of English law and, as I've mentioned, applicable to interpretation of contracts, but it is not invoked at every opportunity to fill holes which a civil law might feel exist. In the end, I suggest that the common law view of contractual parties' duty to cooperate where it's not an express term of the contract is that it has to be an implied term, and a term can only be implied to the extent that it is strictly necessary to make the contract work or enable the contract to be coherent. Another development of the English courts is that despite the strong words of Lord Ackner in Walford about the law not recognising a duty to negotiate in good faith, there is in fact a duty to negotiate in good faith in common law where parties are already in a contractual relationship and the contract contains a term requiring them to negotiate. Thus, in the recent ABB case, Mrs. Justice Rose held that a contractual obligation to renegotiate a contract in certain circumstances was enforceable. And the Australian courts have recognised as enforceable a contractual term which requires the parties to undertake genuine and good faith negotiations with a view to resolving the dispute. As President James Allsop in that case said, where commercial parties have entered into obligations, they reasonably expect the courts to uphold those obligations, whereas what Lord Ackner was dealing with in Walford and Miles was negotiations where there was no contractual obligation to negotiate. So this is not an exception to the normal approach of the common law. It's merely an application of its desire to give effect to what the parties have agreed. And it shows that there are occasions when the common law courts will invoke good faith, but only when it appears to be necessary to give effect to the parties' intentions. Another area where the common law invokes good faith in the contractual context is where one of the parties to the contract is given a discretion. In one case, a charter party gave the ship owner the right to refuse to obey the charterer's instruction to load or discharge at a particular port if the ship owner considered it dangerous. And there was an issue whether the ship owner's statement that it considered the nominated port dangerous was challengeable by the charterer, and if so, on what basis? The Court of Appeal said that it was challengeable on the basis that where A and B contract with each other to confer a discretion on A that does not render B subject to A's uninhibited whim. The authorities show that not only must the discretion be exercised honestly and in good faith, but having regard to the provisions of the contract by which it's conferred, it must not be exercised arbitrarily, capriciously, or unreasonably. This approach has been approved and effectively adopted in a number of subsequent cases where one party is required by the contract to exercise a power which affects the other party under the contract. In one of those cases, the Braganza case, the Supreme Court concluded that the approach in cases where one party is given a discretion to affect the rights of the other party, there should, in addition to a requirement of good faith, be imposed a test which was very close to the public law test of reasonableness or rationality, which, as the court in Braganza said, has in recent years played an increasingly significant role in the law relating to contractual decisions, where the law's object is also to limit the decision maker to some relevant contractual purpose. Traditionally, as I've mentioned, English courts are very comfortable with the concept of reasonableness. And it's interesting to see that the exercise of discretion in Braganza was quashed by the majority of the Supreme Court on grounds that although the decision was reached by the decision maker in good faith, it was unreasonable, having been formed without taking relevant matters into account. Reasonableness plays a very important part in the common law more generally, and I've already mentioned the role it has as the arbiter of assessing what the contract means. And reasonableness can be invoked by common law judges to justify limiting the extent of legal rights obtained or granted by a contract. Turning to rather a different aspect, the common law's invocation of equity is often cited as a partial equivalent of the civil law good faith, and the equitable rules against unconscionable bargain was, it will be remembered, an example cited in the Interfoto case by Lord Justice Bingham. But English courts have traditionally been very chary of holding that equitable principles should apply to commercial contracts. In a lecture in 2018, Lord Briggs in the Supreme Court cited an article by a predecessor and a law lord, that Master of Equity, Lord Millett, who had suggested that uncontrolled extension of equitable doctrines, remedies, and principles into the commercial field was in danger of doing more harm than good, and could undermine both the desirable certainty of English commercial law and the valuable role performed by equity in regulating the conduct of professional trustees and other fiduciaries practicing in the commercial sphere. While Lord Briggs appears to have agreed with this, he also made and developed the point that particularly with the increasing role of professional fiduciaries in fields such as financial services, equity had an important part to play in commercial law, and more particularly, some equitable principles were of value generally, and others had a part to play, a familiar common law observation, as you will have gathered. So the equitable remedy of rectification should be available in relation to all commercial contracts. That is, where it's established that the written contract does not, in fact, record what the parties had both agreed and intended. And estoppel, which basically involves holding people to their promises or statements, where it would be wrong to permit them to resolve from those promises or statements, is another important example of an equitable principle which can be invoked in a commercial context, albeit that it may be harder to invoke it in a commercial context than a non-commercial context. But equitable rules that contractual time limits should not be strictly observed have no place in commercial contracts. The possibility of a general implication of good faith into common law commercial contracts was suggested by Mr. Justice Leggett, now Lord Leggett in the Supreme Court, in the Yang Sen case and in two subsequent cases, where he seems to have limited the suggestion to so-called relational contracts. The 8 or 9 ingredients of a relational contract were then identified by Mr. Justice Fraser in Bates and the Post Office. Although there are some supporters for this development, there are also some critics. I must confess to being in the latter camp. In Yam Seng, it seems to me that Mr. Justice Legate's notion of good faith was little more than honesty and lack of bad faith. And anyway, as was pointed out by Professor O'Sullivan, the facts in that case were exceptional, as the agreement was skeletal and homemade, and anyway, the two specific terms implied by Mr. Justice Legate readily satisfy the usual test for implication of terms. As for the concept of a relational contract, it is vague, and as Professor O'Sullivan has also said, the various suggested criteria represent an unhelpful structure lacking certainty and likely to generate increased litigation. I've rather arrogantly been equating English common law with English law and have not referred much to Commonwealth law. In Australia, the High Court observed in 2014 that whether there is a general obligation to act in good faith in the performance of contracts, and whether contractual powers and discretions may be limited by good faith and rationality requirements are still open questions. But it's unclear quite how wide a concept of good faith was there contemplated. Australian courts have generally adopted the same approach as English courts when it comes to good faith in commercial contracts. And the Singapore Court of Appeal has held that there is no general duty of good faith to be implied into commercial contracts, and the New Zealand Supreme Court has not accepted an invitation to take a different court. By contrast, the Canadian courts appear to have been more prepared to go down the good faith route, but quite how far remains unclear, not least given the sharp difference of opinion in the 2020 Callow decision. I briefly referred earlier to the importation in good faith into international arbitration. This did not go unchallenged. In an article written some 35 years ago, the late Lord Mustall, a commercial lawyer of the first rank, then a first-rank commercial judge, and later an international arbitrator, protested strongly at the invocation of lex mercatoria in international arbitration. With respect to him, I'm not sure how much of a problem this is. Most commercial arbitrations involve applying the law of a specified jurisdiction. And if that jurisdiction recognizes good faith, then it must be followed. And per contra, if it does not recognize good faith, then that must be followed. ICSID arbitrations are different, but they will normally involve public law type questions, where civil and common law appear, at least from my experience, to adopt fairly similar approaches in practice, if not in nomenclature. Indeed, much of English public law can be traced back ultimately to French public law. But I accept that there is a residual but significant group of arbitrations where there can be room for argument whether or not lex mercatoria in general, and good faith in particular, should be applied. The jurisdictions which are most relevant to the dispute should, I suggest, influence, possibly decisively, the resolution of the issue. The identity of the arbitrators will, I suspect, play a significant part. And if both co-arbitrators come from similar jurisdictions, one can see a fairly strong argument for saying that that is not unreasonable. As a common lawyer, I have to accept that, subject to one point, it can be argued with force that various international conventions on contract law involve the invocation of good faith, and that that is a significant factor in favor of invoking good faith in an arbitration where the arbitrators are not required to apply the law of any particular jurisdiction. Thus, the UN Convention on Contracts for the International Sale of Goods stipulates that in interpreting the convention, regard is to be had, among other things, to the observance of good faith in international trade. And the UNIDROIT principles require each party to act in accordance with good faith and fair dealing in international trade. And of course, EU contract-related legislation often includes good faith requirements. But things are not quite as simple as they appear. As I've mentioned, courts in many common law jurisdictions now accept that good faith may have a part, albeit a very limited part, to play in the law of contract. But before the civil lawyers claim victory, even where good faith can be invoked in the English courts, it has to be said that the common law idea of good faith appears to be very pallid when compared with the full-blown civil law version. Thus, in a case where the parties had expressly agreed that good faith would apply to their relationship, the English Court of Appeal said that, just like any other contractual provision, an express clause in a contract requiring a party to act in good faith must take its meaning from the context in which it's used, so that other cases involving different contracts and different circumstances are of limited value. In those circumstances, the court said that apart from the core duty of honesty, and depending on context, a duty not to engage in conduct which could be characterized as bad faith, any further requirements of an express duty of good faith must be capable of being derived from the other terms of the contract in the particular case. In other words, it seems to me the court was saying that unless the express contractual terms indicate otherwise, an express agreement that one or all of the parties will act in good faith will apparently be limited to requiring honesty and lack of bad faith, but nothing more. This seems to me to indicate a distaste on the part of the common law judges for a wide-ranging role for good faith in the contractual context, even where the parties have specifically agreed that it is to apply. It is at least arguable that it goes a little further and suggests that unless the contractual context otherwise indicates, an express obligation of good faith does not add much, as even without a good faith provision, the common law, a civil lawyer might say even the common law, expects parties to act honestly and not in bad faith. In another Court of Appeal case, it was said that where the parties had agreed to act with the utmost good faith towards each other, the Court of Appeal held that this meant that they had agreed to observe reasonable commercial standards of fair dealing and to be faithful to the agreed common purpose and to act consistently with the justified expectation of the parties. But I'm not sure that to an English lawyer, fair dealing means much more than honesty. And the common purpose and justified expectation of the parties could, as I see it, only be assessed by reference to the terms of the contract. Unsurprisingly, in 2017, a Paris Institutional Arbitration Tribunal took a rather different view when giving effect to an English law contract, which provided that in carrying out their obligations under the contract, the parties shall act in accordance with good faith and fair dealing. The tribunal said that such references must be given their full importance, and after pointing out that the contract is not a standard English contract and has not been entered into between parties that are both coming from, and has been entered into between parties that are both coming from civil law countries, the tribunal concluded that it could refer to the UNIDROIT principles, which unequivocally recognized as embodying these principles of law. In other words, the tribunal accepted a full throttle assumption of good faith. But arbitration assumptions are not all minded to give effect to good faith. In a later London institutional award, where UAE law applied, the tribunal said that the fact that the claimant invoked its contractual right cannot itself be deemed as a manifestation of good faith, and went on to say the agreement sets out in sufficient detail, sophistication and clarity the obligation of both parties, and the claimant has not deviated from what was contractually agreed, and so no breach was found against the defendant, against the claimant, very much what might seem to be a familiar common law approach. In summary terms then, the role of good faith in civil law is both wider and deeper than in the common law. In civil law, good faith is a general principle which cannot be contracted out of, and which can impose significant duties on the parties that can go further than what is necessary to enable the contract to be performed according to its terms. The common law has specific and relatively limited doctrines which can be seen as aspects of good faith and which are subject to well-established rules. And although in certain specific circumstances the common law does invoke good faith, when it does so, good faith must be expressly or impliedly required by the terms of the contract, and the common law's concept of good faith is normally more limited. But there is more similarity between the two systems than first appears. In an impressive comparative analysis of French, German, and English cases on contract law, Professor Walker discussed those who think that civil and common law are converging, and those who think they are diverging. And she concluded that convergent theorists are right from the standpoint of the outcome of the judicial decisions, whereas divergent theorists are right from the standpoint of what appears to go on in the jurists' minds. So the two systems have very different approaches and take different routes, but very often appear to come out at the same answer. To a pragmatic common lawyer in particular, and certainly to litigants, it is the ultimate decision that matters. I referred earlier to Francis Bacon's description of ants and spiders and compared the common law to the ants and the civil law to the spiders. Francis Bacon continued, "The bee takes a middle course. It gathers its material from the flowers of the garden and of the field, but transforms and digests it by a power of its own. It neither relies solely or chiefly on the powers of the mind, nor does it take the matter from which it gathers from natural history and mechanical experiments and lay it up in the memory as a whole as it finds it. But it lays it up in the understanding, altered and digested. Therefore, from a closer and purer league between these two faculties, the experimental and the rational, such as has never yet been made, much may be hoped." I believe that both the common law ant and the civil law spider have tended to develop bee-like qualities, partly through the passage of time and partly through the two systems learning from each other, particularly thanks to the increasing internationalization of law, which is most conspicuously evidenced by the growth of international commercial arbitration. The common law has developed and expanded rules which reflect civil law good faith and has occasionally embraced good faith, while civil law pays great respect to the importance of freedom of contract and party autonomy, albeit under the umbrella of good faith. I think Emmanuel Gaillard would approve. Thank you very much.